Daniel Finling with Finling Law and thedivorceguy.com. And in this webinar, we're going to discuss choice of school when parents cannot agree. Let's get started. Here's an outline of what we're going to discuss. We need to evaluate and consider joint legal custody. We're going to discuss a Lombardo hearing, and the majority of our time we're going to discuss the seminal case on choice of school in Michigan, Perrin versus Perrin. Let's talk about joint legal custody. In most Michigan cases, the parties are awarded joint legal custody. That has nothing to do with parenting time or even physical custody for that matter, which defines the frequency by which each parent spends with a child. Even if we have disparate parenting time, Michigan will provide, in the majority of cases, that the parties will be awarded joint legal custody. So what does joint legal custody really mean? It means important decisions concerning the welfare of the child. These really big decisions like moving to another state, changing schools, or healthcare decisions are important decisions affecting the welfare of the child, and joint legal custodians have equal say without consideration of how often a child is with one parent or the other parent. And the case that tells us that is this Bowers versus Vandermeulen-Bowers case, which says that choice of school cases is an important decision and joint legal custodians decide. But what happens when they cannot agree? So let's talk a little bit about a Lombardo hearing. When parents cannot agree, the court will decide. It is an evidentiary hearing. Sometimes it's brought in front of the friend of the court first for a recommendation, but ultimately the judge will make a decision when parents cannot agree on a choice of school issue, and that hearing is called a Lombardo hearing. A Lombardo hearing is simply a hearing in front of a judge or a friend of the court referee sometimes for a recommendation, and it's named after the parties that brought the case. Mr. and Mrs. Lombardo sued each other over an important legal custody decision. And what Lombardo tells us is that in making a determination of these important legal decisions, like choice of school, the court must look to the statutory best interest factors as a guide. The seminal or most important case in choice of school in Michigan is a case called Perrin versus Perrin. This really defines how we examine a choice of school case. Let's take a closer look at Perrin. The background of Perrin is relatively simple. The ex-wife moved to Grosse Pointe, Michigan, and the child was attending school in Howell. The trial court said that the child should remain in Grosse Pointe schools, and the wife said, no, I wanted to move that child to Howell. And in examining Perrin and saying that we have to do this Lombardo hearing, the Perrin court gives us precise directions about how to examine a choice of school case in Michigan. So what does Perrin tell us? The first thing Perrin tells us is the burden of proof that we must use when looking at a choice of school issue. That is, when we're examining the best interest of the child, how much do we have to prove that it's in the best interest of the child that the child should go to school A versus school B? Now, an established custodial environment says, with which parent does the child look to for the regular necessities of life over an appreciable period of time? That's a summary, and the statute is 722.271C. As a general proposition, if a child is residing with one parent the majority of the time, then he or she is going to look to that one parent for the regular necessities of life over an appreciable period of time. If the child is living 50-50, then with both mom and dad, as the case may be, then it'll be determined that there's an established custodial environment with both mom and dad. Because what the established custodial environment designation does is tell us whether we have to prove by preponderance of the evidence or by clear and convincing evidence that the choice of school is appropriate. So what do I mean by that? Well, preponderance of the evidence was described to me in law school more like the scales of justice. Is that a little bit more favor one school district or the other school district? That's preponderance of the evidence. So looking at the best interest factors narrowly tailored to the choice of school issue, is it more likely or not that the child would be successful and have a better academic environment in school A versus school B? So if there's no change in the established custodial environment, that is, if we're moving the child from one school to another school and it's not going to result in that other parent having more parenting time now, changing who the child looks to for the regular necessities of life for an appreciable period of time, the burden of proof is preponderance of the evidence. However, if there is a change in the established custodial environment, the burden of proof is clear and convincing evidence. And this is the second highest burden of proof we have under Michigan law. The highest burden of proof that we have is beyond a reasonable doubt. When we evaluate whether somebody should go to jail, you don't send him or her to jail unless it's been established beyond a reasonable doubt. Clear and convincing evidence isn't that high, but it's almost that high. So what does that mean? That means if, for example, the child or the children are living with mom and there's an established custodial environment with mom. The children spend the majority of time with mom. Dad wants the children to go to a different school district, but there's no established custodial environment with him because it's with mom. In order for the court to order the children to change school districts, Dad must prove, utilizing the best interest factors narrowly tailored to the issue of choice of school, that there's clear and convincing evidence to change schools. It's a much higher burden, and Dad has a tougher job if there's no established custodial environment. Now, when we take a look at the statutory best interest factors, which are the same best interest factors we use when evaluating a custody case, many of them may not be relevant to the issue of choice of school. And what the parent court says, and this is a quote, I have it here on the slide, after analyzing all the best interest factors, it should be clear that the proposed change of school district is or is not in the best interest of the child. But we look at the relevant factors. Let's take a quick look at what these 12 best interest factors are, and then spend a little bit of time talking about what evidence we need to demonstrate or present to the court to argue and convince the court that the choice of school or the lack thereof is in the child's best interest. I'm not going to read all the factors to you, but I have the first 4 on the screen: the love, affection, existing emotional ties between the child. Now, I don't know how that could be relevant to a choice of school issue, but what about the length of time the child has lived in a stable and satisfactory environment and the desirability of maintaining continuity? Factor D. If a child, for example, has roots in one school district, his or her friends are in that school district, they're engaged in extracurricular activities with that school district, certainly factor D would be relevant to that choice of school issue. Let's look at some of the other factors. All right, factor H, the home, school, and community record of the child, is very important, and you can narrowly tailor that to the issue of choice of school. By way of example, if a child has failing grades, even though mom is the primary custodial parent in mom's school district, well, that may be clear and convincing evidence that, and when the child with daddy does all his homework, dad does everything else, that may rise to the level of clear and convincing evidence to change school districts. So the home, school, and community record of the child would most likely be really relevant in a choice of school case, along with the preference of the child. The preference hates schools, getting in fights with children, doesn't like what's going on. That may be relevant as well. And let's look at the last factors, and we'll try to summarize the issues. And sometimes this is result-driven analysis. In other words, you make your arguments first on why the choice of school should take place, and then you try to match them up, sort of like almost like a game, like match game, right? And say, okay, well, this is applicable to this factor or this best interest factor. But let's continue. And if we look at factor L, any other factor considered by the court to be relevant to a particular child custody dispute, that's really where we can play that match game. For example, we may have an argument related to choice of school and we don't know where to plug it into a specific best interest factor. You can always rely on factor L. Well, this is another reason why. Because Lombardo once again says that when a court is making these decisions regarding important legal decisions in a joint legal custody environment, it must use the best interest factors. Perrin tells us what the burden of proof is, and then says, all right, you have to narrowly tailor it to the best interest factor. Well, factor L, the catch-all, gives us that legal authority to do that. So what evidence would you try to submit to support a claim or a defense to a claim to change schools? Well, you can use standardized test scores from the different school districts, class size, child's current performance in school. If you have a child maybe that has special needs, the special programming, whether it's talented and gifted programming or programming for an autistic child, that certainly is relevant to choice of school. Extracurricular activities, the availability of daycare, latchkey, how long the child has to stay home alone in one home versus the other, the distance, whether he or she has to walk or take a bus. We look at school district ratings. You can go on bestschools.com and other data and get information. And of course, the child's friendships, right? He has engaging relationships within friends within a specific community or another, and we want to maintain continuity. We can also bring in experts, right? We can bring in a child custody expert, an education expert, and so forth to talk about and to provide evidentiary support why one school district may be more preferable than another school district. And what we do is we play match game again. Class size. Well, what best interest factor of those 12 factors that we reviewed would class size really fit into? The only one that I can think of is factor L, right? But friendships certainly would go to the permanence of the family unit, right? Because the family and friends and so forth, that's a little bit more of a direct link, I should say. So let's summarize for just a moment what we discussed. There's a lot of information, right? Joint legal custody tells us that parents are going to share these important decisions like choice of school. Lombardo instructs us that we have to use a best interest analysis in determining these important decisions when there's a dispute between parents. And what Perrin tells us is that we have to make certain that if this affects the established custodial environment, what burden of proof do we use? Do we use preponderance of the evidence, or we do use clear and convincing evidence in making the argument, right? How much evidence do we have to use to support the decision to change schools? And then when we look at the best interest factors, Perrin also tells us that we have to narrowly tailor these arguments that we're making, like class size, maybe special programming and so forth, to best interest factors. There's a lot of information here. I recognize also that you may be confused and have additional questions. If you do, I'm here and available to help. I want to invite you to contact us if you have additional questions. My phone number is 248-399-3300. You can always visit our website, thedivorceguy.com, or feel free to email me at daniel@findlinglaw.com. I'm Daniel Findling with Findling Law and thedivorceguy.com.